Hi, welcome to Inside Senior Care, where we discuss all things senior care. My special guest today is attorney Jonathan Thompson. Jonathan specializes in elder law. Welcome, Jonathan.
Hi there, Margot. How are you?
I'm good, thank you, and thank you for joining me. So, can you give a little bit of background about yourself and why you chose to specialize in elder law?
Sure, Margot. My name is Jonathan Thompson, and I've been an attorney for a little over 11 years. My office is in downtown Walnut Creek, California, and we've been here for many decades, the business. Something that makes me kind of unique is that I'm a part of a four attorney firm, and we're all related as family members. There's both my parents are attorneys, my sister and myself. So that's what makes us pretty unique. I don't know of any other four attorney firms who are all family members here in the Bay Area. If there are out there, I have not yet seen them, but that makes us pretty unique. Our practice, we focus on primarily estate planning, so drafting documents like wills, trusts, powers of attorney, healthcare directives, that sort of thing. We also do trust administration, probates, and even something called conservatorships. So we kind of, all of these things are kind of interrelated, and those are our specialties.
Thank you. Very good. So good. So elder law is a large term. We had talked about that, right? And it includes a lot of different services. People see it and they go, they don't even know what that is, right? What's the difference? Can you just discuss or kind of define what is elder law and then who does it help?
Sure, Margot. So elder law is kind of a generic and overarching term that can refer to several different areas of the law. Elder law can relate to estate planning, so setting up a will or trust or other estate planning documents. Elder law can also include something called a conservatorship, which is a court supervised process where someone makes decisions for someone else about their health and or their finances. And then elder law can also include something called elder abuse or something like this. And then lastly, elder law can refer to something called long-term care planning, something like qualifying for Medicare, Medi-Cal, or other means-tested benefits if someone is headed towards nursing home care.
I see. So someone that is needing any type of legal help as they age, right? Is that kind of
Yeah, I think that's accurate. I think that's accurate, and not everybody who is older needs to consider estate planning. I think everyone should consider estate planning, but
right? True. Very good point. Very good point, Jonathan. So that leads me to my next question: is when should someone seek out an elder law or an attorney? So it's an overarching term, so it could even be estate planning, really, right? So when should
yeah,
someone seek out someone like you that provides these services? When is the right time for that?
I think in one of two circumstances. Number one, if somebody is having some sort of life change, if they're moving to California, if some loved one of theirs has passed away, a spouse has passed away, a parent perhaps has passed away, or is needing a higher level of care. I think that's one instance where somebody should be thinking about elder law, thinking about what their options are. That's number one. And then number two, if somebody is here in California and they either own real estate or they have assets that are significant enough to trigger something called probate, then they should also seek out an elder law or estate planning attorney.
When would that happen? When would a probate situation? Can you explain that a little bit?
Sure. When people hear the word probate, they usually associate it with something negative. Okay. Probate is the court supervised distribution of assets to somebody's heirs or through a will. And whenever you hear the term court supervised, I want you to think expensive, time consuming, and unnecessary most of the time. So we want to avoid probate. We don't want to go to court. It's a public proceeding and it's avoidable. So to do that, to avoid that, somebody should seek out a qualified estate planning attorney to discuss what their options might be for their assets, their family situation, and maybe that would involve setting up some of these legal documents.
I see. Okay. So then I guess that kind of leads into our next question, which is the difference between wills and trusts. This is one of the biggest questions I get all the time. People don't understand that. So can you kind of discuss those two things? I think that might also discuss the probate, right? Or no, I don't know.
Yeah, I think they're related, Margot, and these things can be a little confusing. So one of the first questions I ask my clients is whether or not they need something called a trust. So a trust is a legal entity that holds title to certain assets, okay? If you own property in California, I recommend that my clients set up a trust, okay? Now a trust will hold title to that property through a trustee, and a trustee manages the property, and usually it's the person who comes to see me is the trustee, the person who puts together the trust. If somebody becomes incapacitated during their life or they pass away, then the successor trustee can step in and either manage the property for that person during their life or distribute the assets, sell the property, or distribute it to the beneficiaries. So a trust is efficient and necessary if you have sufficient assets or you own real estate, or perhaps if you have young children, okay? So not everybody needs a trust though.
Okay.
Not everyone has real estate or significant assets. Maybe they have assets with beneficiary designations or just retirement accounts or something else where these assets can flow after they pass away. And so maybe they don't need a trust. Maybe they just need something called a simple will. And a will does two things. A will says who gets what, and then who is in charge after you pass away. That's called an executor. So, Margot, it all depends on what type of asset somebody has and what type of goals they have for their assets if something happened to them.
Thank you for that. That is always the question. And it's not one or the other. It's really dependent upon a lot of different factors. Thanks for that. So what some people will ask, can we do it ourselves? And I always recommend that they see an attorney. And I've worked with you often. You're wonderful. You've helped a lot of people that I've helped. But when they ask that, what would your answer to that be? Like doing it yourself versus having an attorney actually do it?
Yeah, so I'm never adverse to those who like to do their research and consider doing it themselves. I think that in some instances that works out just fine. There's different books out there, different resources. There's publications by a group called NOLO, N-O-L-O, NOLO Press, who puts out books about how to do certain things, simple estate planning. So I think that that's admirable that for people that do that. There's also in California 3 statutory type documents, and the word statutory means that these are codified, and there's forms out there that are kind of fill in the blank. Okay, there exists a statutory will where you could write who gets what, who your representative is, and you can get it executed. Okay, and there's very specific ways that you have to do this execution. So the statutory will is one. There's also something called a statutory power of attorney, and I'll talk about that in a moment. But a power of attorney is a document that it's good during life for financial management. And then lastly, there's something called a statutory healthcare directive or a fill-in-the-blank type form healthcare directive, okay? These are available in California, and I think they're better than nothing, okay? I do think, though, that if somebody needs a trust or they have some complex wishes, that they consult with an attorney to see what value the attorney can bring to doing their documents. Because The last thing we want, Margot, is for these documents to be ineffective and not work. We also don't want someone to mess something up. So, for example, I've dealt with situations where someone puts together a trust at one of these, paralegal services or fill in the blank forms, and the people, they don't do it properly. And I know they meant to do everything properly, but they don't, and something gets messed up, and the cost and the time to fix that problem far exceeds what it might cost for an attorney to help. So most attorneys like me or other attorneys in other places offer a consultation to sit down with them, or during the pandemic talk to them over Zoom or or the telephone or other electronic means, and feel them out. Say, hey, these are the assets I have. These are my goals. This is what my family's like. What do you recommend? And then how much does it cost? So just like doctors, Margot, there's many attorneys out there who could get the job done, but it's important to find someone you like and to find someone who has a price that you're okay with. So in all of this talk, Margot, I think that some people can do it themselves and have no problems, but with trust and other more complicated documents, it always makes sense to consult with a lawyer.
Good, very good. So you were saying doing consultations, because you do consultations to see if it's a fit first before they jump in and do it themselves. I think that's a great idea. Is there something that you would tell them that they should look for when they're looking for an elder law attorney, if they decide they want to do a consultation first before they make a decision?
Yeah, so attorneys like me, we offer a kind of a free consultation, with regard to estate planning and other issues, because it's very important that you like your attorney that you're working with.
Right.
That always pays to do, and you want to make sure that you like the person too. So
Yes. And so liking them, feeling comfortable with what they're saying, and also the cost.
That's right. And some people are uneasy about those attorneys who charge a fee to do a consultation, and I understand. So it's all about the match.
Yes, I agree with you. So we wanted to touch a little bit on the power of attorney. That is something that's done. Can that be done separate from the trust and will, or is that something that has to be included in those documents, or is that something that?
Yeah. So that doesn't necessarily have to be done in conjunction with other documents. A power of attorney. Some people argue, Margot, that the two documents that are the most important for anybody, especially seniors or those who have life changes, are this power of attorney that you referenced and something called an advanced healthcare directive. So the power of attorney is a document that allows somebody else to step in your shoes for purposes of medical decision making, or I'm sorry, financial decision making.
Mhm.
So if you have a power of attorney, someone can write checks for you out of a checking account, or transact business, or do other things, move money around regarding assets outside of a trust if you have a trust. Okay. So the power of attorney is very important. Okay. The second one that I mentioned, Margot, is the advanced healthcare directive. So this is a document that allows an agent to step in your shoes for purposes of medical decisions.
Okay.
Okay. So if you have a power of attorney for finances and a power of attorney for healthcare, then you're covered, or another senior is covered, in case they lose their capacity, in case they lose their ability to make these decisions themselves. Okay. And if somebody loses that ability, and there's no one with authority to make these decisions, then the senior or someone else may have to go to court and get something called a conservatorship. Okay. And that's a court supervised process. Now, you always want to do a cost benefit analysis, having nicely set up estate planning documents like a power of attorney and a healthcare directive versus going to court, because going to court is always more expensive than getting this stuff done.
So it's really important to have these things done before something happens. So when we say, when is the right time? I think that question you've answered beautifully in that get always having it done, getting prepared way in advance and preparing for your estate and all of these things so that you have it in place beforehand. I think you've answered that beautifully in that if it's not done, it's going to be very hard for whoever's caring for you to truck up a uphill battle with all of these, right? It's not going to be as smooth. And when people are aging, the last thing that families want to do is have to go through all of this. They want to be able to manage your care easily, right? And with ease, because you already have that emotional piece of it. So I think you've answered that wonderfully in that if it comes to that point, you can get help, but it's always better to plan, right?
The best part, Margo, the best part about estate planning is getting it done and feeling comfortable that it's done and that you don't have to worry about it as long as your wishes don't change.
Very good. I see. And then really quickly, you touched on the incapacity. So if someone doesn't set this up, they have assets and they haven't done anything, then all of a sudden they get dementia. They go into the hospital. We see this often. And now they don't have capacity to make this decision. What happens then?
Um, well, sometimes family tries to informally assist, uh, and sometimes that doesn't work. Alternatively, we look to what type of assets are out there. Did they have any joint accounts or put anyone on as a joint signer for financial transactions? But if something happens to someone, they lack capacity, they can't make medical choices for themselves or financial choices, then um, this is when these documents kind of take effect a lot of the time. But if they don't have those, then you're going to have to find a conservatorship attorney to start the process of a conservatorship, which is very expensive. It's very public. We're going to court, and remember that's court supervised also, so it's very expensive. And a conservatorship lasts until somebody regains their capacity. So for seniors, a lot of the time it lasts for the rest of their life.
Wow.
And whenever, if you have over a certain threshold of assets, you have to do something called an accounting to the court periodically. So all this stuff is very expensive and avoidable. So it's always a good idea to get this stuff together, but I'm preaching to the choir.
Very good. Good. Thank you so much. This information is just so valuable. So, how can people get a hold of you if they want to talk to you or do a consultation with you? Now, you can cover all of California, right?
That's right. I'm licensed in California. The court work that I do is primarily around the Bay Area region, but other estate planning documents, I can assist people within the California, anywhere in California. So if someone wants to get in touch with me, again, I'm Jonathan Thompson. My law office is here in downtown Walnut Creek. You can Google me or look me up online. Otherwise, my phone number is 925-935-5566. Again, it's Jonathan Thompson in Walnut Creek.
Do you have an email address?
Sure. It's my first name, Jonathan, and then it's at thethompsonlawoffices.com. So it's a big mouthful, okay? It's Jonathan at, and then all one word, thethompsonlawoffices, plural.com.
Thank you so much for taking the time. I really appreciate it. And
Sure
hope
thing.
you come back soon.
Yes, Margo, thank you.
Thank you.